Welcome to this webinar. This webinar topic is Understanding Committed Intimate Relationships in Washington State. In just a moment, I'll turn it over to Michelle Dellino of Dellino Law Group, who's going to walk through a bunch of information today. And there is an opportunity also to ask questions. So if anything comes up that you would like to know the answer to in the course of this webinar, please go ahead and put those into the Q&A section at the bottom of your screen. You can also put it in the chat, but I think the Q&A section is even better. You can choose to post a question anonymously if you would like. If you don't post it anonymously, it's possible that other people in the session here would see who posts the question, but you can choose to post it anonymously, or you could chat to me individually, the host, and that would also be a way to ask an anonymous question. So welcome. My name is Melissa Rosenberg, and I work alongside Dellino Law Group. I'm actually a mental health clinician. I run a private practice therapy group, and I specialize in working with clients who are going through relationship transitions. So I work with quite a few clients who are undergoing the divorce process or who are considering the divorce process and all of the emotional ups and downs that come along with that. Also work with couples who are trying to contemplate divorce or couples who are trying to repair their relationships. And I'm really happy to be here to assist with this webinar today. So I'm going to go ahead and turn it over to Michelle to introduce herself and get started with our topic of the day.
Great. Thanks for being here today. Today, we're talking about something that is not often talked about, but we're going to talk about committed intimate relationship. I'm Michelle Dellino with Dellino Law Group. We are a family law firm that serves the greater Puget Sound region. We have offices in Seattle and also in Bellevue. We have a team of 6 attorneys and support staff that are here and ready to help you. Today, the purpose of this webinar is not to talk about me or the firm. The purpose of the webinar is to give you information that's going to be helpful for you if you have questions about unmarried relationships, what that means. Living together in Washington and committed intimate relationships is something that is unique to Washington, although other states do have these kinds of issues. Washington has a very specific law that a lot of people don't know about, and they don't know what all of the ramifications of living with someone in a long-term relationship could be. So today we're going to cover committed intimate relationships, how that's different from a domestic partnership, what domestic partnerships are in Washington. So if you hear that thrown around, you'll know. We're going to talk about unmarried parents and how this could impact you if you're an unmarried parent, and what decisions need to be made when ending those relationships or separating from the other parent. We're going to talk about agreements that can be helpful in these kinds of situations, and we're going to answer your questions. So a lot of different things in the next, 55 minutes, right? All right, let's start with committed intimate relationships. This is the big one. And living together in Washington can establish certain property rights that it doesn't in other states. Committed intimate relationships are known as CIRs. So a lot of the time you might hear the term CIR if you're in a relationship like this and it is being dissolved. What is a CIR? The court in Washington that established sort of like the case that deals with all of this is called Connell versus Francisco. That lays out the factors that a court looks at in deciding whether you are actually in a CIR, because you can be in a long-term relationship with someone and it doesn't mean it's a CIR. But most of the time, that's kind of what people are looking at, is evaluating whether it is a CIR and what that means for you. But what is it? It's a stable marriage-like relationship where both parties cohabitate with knowledge that a lawful marriage doesn't exist. So that's a definition from that case. What does that mean? It means you live with someone, you know you're not married, so you don't think maybe you're married. Sometimes there's misconceptions about that. You know you're not, but you know it's a stable relationship with the other partner, and you know that the intent of that relationship is to be with that person in an unmarried relationship. That's basically what it is, and that's really broad, and it can mean a lot of things. A lot of people will say things like, we've been together forever, but we're not married. Do I have any rights? And the answer is you likely do if you have what can be established as a committed intimate relationship, and we'll get into what those rights are. Unmarried couples in Washington don't have common law marriage. That's another term I want to get out of the way right away. If someone says, oh, we had a common law marriage, the answer is no. Very few states actually recognize common law marriage. Some people used to think, and some people still contact me and say, oh, we've been living together for 7 years, so we're married, it's a common law marriage. That's not a thing in Washington. It is in, I think, I think 3 other states other than ours, but it's not a thing here. But if you think you might be in a common law marriage, you might be in a committed intimate relationship. So that's important for you to know. These relationships exist when a couple lives together for a significant period of time. And we'll talk about how long that may or may not be. There are property rights that you're going to establish through these relationships that are really important for you to know. And it's really important for you to know either if you do live with an intimate partner, you're thinking about living with an intimate partner, or your relationship with that intimate partner is coming to an end. It's important that you understand that you potentially do have rights, and it's important for you to understand what they are and to be aware of them. A lot of people are in committed intimate relationships and don't even know it until the relationship ends, and then they realize, oh wow, it doesn't matter that my bank account was only in my name. That other person might have a claim to it, and that can be a very scary thing for people to realize. Other thing about committed intimate relationships, you might hear the term, I'd like to just get all these terms out of the way. You might hear the term meretricious relationship. That is no longer a thing in Washington either. That is what committed intimate relationships were called before the CIR concept was coined in Marriage of Lindsay and Connell versus Francisco. And now we call them committed intimate relationships. It's a friendlier term. It's basically what it sounds like. So that's what we're talking about. You're not talking about common law marriage. You're not talking about a meretricious relationship, and you're not talking about a domestic partnership. You are talking about a committed intimate relationship. The other thing to know is that committed intimate relationships apply to same-sex couples, and they apply to opposite-sex couples. So it isn't that some people will say, well, we chose not to get married, so that was a decision that we made and we shouldn't fall under this. It should only be for same-sex couples. Well, now we have marriage equality, so anybody can get married. And committed intimate relationship is totally gender blind. It has nothing to do with that at all. In fact, we deal with a lot of committed intimate relationships at our firm. It's kind of one of the practice areas that, for whatever reason, those people have gravitated towards us and they find us. And so we deal with a lot of these cases, whereas a lot of other family firms don't. And I can tell you that in committed intimate relationships, it's most very commonly opposite sex couples. So it's not like it's specific to same sex couples. It can be anybody. So that's really important for you to know. I hear a lot of objection about that at times, because sometimes people feel it's unfair. They feel they made a decision not to marry, and so there should be no property rights attaching. But you know, you live in Washington and that's the law. So let's talk about how a committed intimate relationship, I'm probably just going to refer to them as CIRs because it rolls off the tongue better. But how is a committed intimate relationship determined? How do you know if you have one? That's kind of the pressing thing. Everybody wants to know, does this count? Do I count? Does our relationship meet the threshold? And the answer that people don't like to hear, but is so true, is it depends. There's not a hard and fast, I've lived together this many years, I've done this, we're definitely a committed intimate relationship. It doesn't work that way. There's not a specific criteria or distinct formula to determine if the relationship is going to be considered a CIR. The courts use a number of different factors when making that decision. And some people will call them the Connell factors because they're derived from that specific case, although that's boring to most non-lawyers. So some of the factors that can be taken into consideration, I'll kind of go through the things that are going to be looked for in a court case, or that your attorney is going to talk to you about and try to get at the heart of what was really going on here. One of them, how long was the relationship? And we'll talk about this as well. I'm going to touch on it here. And people sometimes have questions about this, but I do want to touch on it here. How long was the relationship? Great question. Some people think if I'm in a committed intimate relationship, it had to be 7 years or it had to be a long time. False, not true. I have litigated committed intimate relationship cases where 2 years is a committed intimate relationship. Less than 3 has been officially found to officially be the length. It could be less than 3 years, and a court has found that that's going to be what the length is. So that is what it is. The next thing to know is there a maximum length? No, not a maximum length. There's absolutely not. It can be anything. The thing to know about that I think is really, really important is if you're looking at a situation where you've been together for a certain amount of time, but you weren't living together. That's a really important factor. Continuous cohabitation is extremely important. When did the cohabitation start? So if the cohabitation started at a certain point in time, that is going to be probably when your committed intimate relationship begins. If you were in a dating relationship but not living together, let's say I've had cases like this come up where maybe you were together for 10 years in this stable relationship, but you weren't cohabitating the whole time. The committed intimate relationship period is going to begin when that continuous cohabitation began. If you were back and forth, but mainly living in one place, that can be an issue that can be discussed with the trial court. But the most important thing is going to be how long was the relationship and when did the cohabitation begin? Those are like hallmarks for just getting into that phase. And then what was the purpose of the relationship? This is the other thing. You could be living with somebody and the purpose maybe isn't a mutual, intimate relationship. Maybe the purpose is we're saving on costs. Maybe the purpose is we're roommates or we're family friends. That's not a committed intimate relationship. It is what it sounds like, committed and intimate. The intentions of the parties is really important. In trying a committed intimate relationship case, there will often be testimony from people about, what they personally observed. Were the parties intending to marry? Was there discussions about that? Or were they just intending to be together, for a really long time? What was the intent? And that all goes back to, was this just a dating thing or not? Next thing is, did you hold yourself out as a couple? This is really important. Couples that maybe didn't tell anyone, or it was a secret, or nobody knew because maybe they were, I don't know, for whatever reason, that's something that can cut against you in a committed intimate relationship case. If nobody knew that you were a committed couple, then you weren't holding yourself out. And holding yourself out is somewhat used in legal context, but what that means is, did people know? Did you talk about it? Was it like, this is my partner, this is my girlfriend, everybody knows it? Or was it something where nobody knew and then you weren't really an open couple? Was it an exclusive relationship? This is also a really, really, really important issue. Whether it was exclusive or not is extremely important. If you're in multiple relationships, it's not a committed, intimate relationship. Some people will say, well, we had an agreement that it was an open marriage, or not marriage, sorry, open relationship. That's different if everyone agreed to that. But for the most part, we're talking about committed and intimate, because the reality is the court isn't going to recognize multiple communities and committed intimate relationships going on at once. If you're married and yet still living with someone else, maybe you're separated, there's actually not a Washington case on that. And that's a real question. And that's a real question. So the reality is, at the end of the day, you want to know, number one, was I in a relationship with this person? And did I know that they're not in a relationship with someone else? If someone's cheating on you and you didn't know that, that can be something that can be argued later. You're still, if they're hiding it from you and not telling you and in another relationship, that's different. But if you just decided we're not really exclusive, you probably don't have a committed intimate relationship. Are you registered as domestic partners? I'm going to talk about this a little later. This is really important. This is really important. Domestic partnership law has changed in Washington. It changed with marriage equality in 2014. There used to be a registry for domestic partners, and there still is, but now only certain people can register. However, if you were registered before, that's pretty strong evidence that this was a committed intimate relationship. Or if you're registered for one of the city domestic partnerships that you can still get, that's also pretty strong evidence. So the court's looking at that. Did you pool resources? Did you buy property together? This is one that's really, really, really on point, and something that comes up in a lot of cases. It goes back to the intent. Were you supporting each other in financial endeavors? Was it like a marriage where maybe both people are contributing to things? Or in some cases, if you didn't pool resources, it's not uncommon where maybe one person wasn't really the breadwinner and the other person was. That can be relevant too. But the court's looking to see, hey, were you guys both paying towards bills? Were you both pooling resources together, is how the court puts it. Did you buy property together? Are you both on title for property? And we'll talk about what happens if you're not both on title and what that can mean. Were you on each other's bank accounts or credit cards? If you had joint accounts, that's something the court will look at as well. If you never did, isn't a deal breaker, because many people don't. But the court will want to know, did some people have somebody's on the cable bill, somebody's on the water bill. How were you guys doing that? Were you, maybe sharing resources that way? But did you have accounts together? That's something the court wants to know. Were you named in each other's wills? Most people don't bother to do a will for whatever reason, which is really frustrating, because later it can be a nightmare, especially if you're in a committed intimate relationship. But if you were and you named that other person in the will, that's strong evidence of a committed intimate relationship. Or if that you or the other person had a will and it names somebody else completely and doesn't include you, and it was done during the relationship, that can be really strong evidence. So yeah. Those are factors. They're not mutually exclusive. The court's not going to put weight on any one more than the other, but it's important to know those are the kinds of things that you're going to get into if you have a CIR case. Determining property ownership rights and division of assets. The court is going to essentially make what's called an equitable division. So what does that mean? If the court finds, hey, you met all these factors, more often, we think this is a committed intimate relationship, and I'll talk about how that happens in a minute, then the court's going to decide about equitably dividing your property. Generally speaking, if the parties are in a committed intimate relationship, all assets, so name on title doesn't matter when you think about this. I have a bank account. My partner has a bank account. We never had joint accounts, but anything during that relationship period, starting with cohabitation until the relationship ends, is going to be found to be community-like property. If you started a business during that time, if one party bought real property during that time, if somebody put money in a 401k during that time, any money coming from wages during that time, also debts. If somebody is racking up credit card debt, that is going to be an issue as well. So yeah. The reality is, at the end of the day, it's going to be very important for you to know everything under that umbrella from when the committed intimate relationship began till when it ended. That's going to be the time period. During that time period, everything is presumed to be community. It doesn't mean that there's not ways to rebut that presumption. So if you're like, hey, I bought this during the relationship, but it came from my money pre-relationship, then you'd probably be able to characterize that as what we would call separate property. The question is it community-like property or is it separate property? The rule is if it's during that period in time, it's going to be assumed that it's community-like. But it doesn't necessarily mean that's the last and final word. There are ways to show that something came from separate property, and it can get confusing. But name on title doesn't matter. If you have a committed intimate relationship, nobody cares whose name the account is in or whose name the property is in. That's something that people don't realize. If you're in a relationship with someone and you work at Amazon and you get a bunch of restricted stock units during the relationship, that comes from wages and income. That's an asset. And the other partner likely has a community-like interest in that. If you put money in your 401k, same thing. If you put money in a savings account, in the stock market, all the same stuff. And that's something that can be very frightening to people who are living with someone in a committed relationship and don't realize that that person may be getting property rights. So how is it divided? I mentioned a just and equitable distribution. So we are a community property state, but we're not a 50-50 state. Some people think community property means we'll just divide everything down the middle if it's found to be community. Well, it would be called community-like property in a committed intimate relationship. And those assets would be divided the same way they were in a marriage, which is along just and equitable lines, not in the middle. What does that mean? What is just and equitable? It supposedly means whatever's fair, but a lot of people think, well, that's completely subjective, and it is. So that's where the court wants to go back to things like, how long was the relationship? Was one party the breadwinner during the relationship? Who's going to recover from the dissolution of the CIR faster? What's going to happen? And that's all really, really important to know. So at the end of the day, let's say you have two parties and one party was more of the breadwinner. The other party maybe did more of this behind the scenes and had a lesser income or no income. The court is likely going to award, and any agreement should likely award, the less moneyed partner, the party who isn't the breadwinner, with more of the community. And some people think that's totally unfair, but why would they do that? They would do that because the less moneyed partner is not going to be able to recover from the breakup financially as fast as the other partner. And the longer the relationship, the more likely that a disproportionate division like that would happen. So let's say you figure out, here's everything in the community. Here's everything from A to B. end to end, that we earned, that assets that were established, we separated out anything that's community. Well, how do we decide how to divide it? We'll try to make what's a fair division, and it wouldn't be uncommon for someone to get 55% and someone to get 45%, or even more or less than that. But that's not uncommon. It doesn't mean things are going to be divided equally. So that's another thing to know. It's also another thing to fight about, and we'll get to how you can avoid doing that shortly. So what are the differences between your rights in a CIR and your rights in a marriage? This is super important. Couples do not receive the same tax benefits as married couples. So a CIR couple is not going to receive the same benefits. You're not filing jointly. You can't. You're not married. And, that's not a thing. So tax benefits are different. Sorry about that. Tax benefits are different. The second thing that's really important to know is there's no spousal maintenance or alimony. In a marriage, not only are you dividing property, but you're also doing a spousal maintenance or alimony award. That's happening. And in a committed intimate relationship, there's no right to that. So while you're dividing property, nobody's going to make you monthly payments when the relationship ends and your court case is over. That's not a right that's afforded to couples who are unmarried. So that's really important to know. Court's only going to get involved in the division of assets and liabilities, no spousal maintenance. If you're not married, you don't get that. That's just part of the law. Another thing, the last thing that's extremely important before I see if we have any questions, I think we do. The next thing is attorney fees. If you're going to fund a committed intimate relationship case, you got to pay for it yourself. It doesn't matter if the more moneyed spouse has the ability to pay and you have the need. That information doesn't matter. So in a marriage, there is statutory law that says you can seek attorney's fees based on need and ability to pay. So if one spouse has more money and you have a need, you could seek fees. Committed intimate relationship case, that's not a thing. You don't have a right to seek fees from the other party on that basis. You could seek fees if you're in litigation and the other party is being what we call, it's a nasty word, but it's intransigent. The other party is being intransigent, they're making things difficult, they're intentionally obstructing litigation. Anybody can seek fees for that. Or if they're refusing to turn over documents and you have to compel the court to give you those, you can get fees in those contexts, but there's no need and ability to pay statute. So you have to know you're gonna have to pay your fees yourself. That's just kind of how it's gonna be. Melissa, I think we have some questions, so why don't we take those?
Yeah, let me pitch a couple questions to you here. The first couple questions are actually pretty related, but let's start with this one. If we're living together after our relationship ended and we separated more than 3 years ago, statute of limitations, but she didn't move out until 6 months ago, does that constitute?
Yeah, that's great.
Yeah.
That's later on. I was going to talk about statute of limitations. There's case law that establishes 3 years. 3 years is the statute of limitations, and you might know that. If the other party, if the relationship ended, but they didn't move out, I hate to tell you this, but you're fighting an uphill battle, because if it was open and notorious that the relationship ended, relationship is done, and we're just still living together, and then you kind of fall into that category I talked about earlier, where you're more of just roommates at that point. If the relationship ended and more than 3 years have passed, you're going to have an uphill battle. And if I was on the other side, I'd probably try to get your case dismissed and thrown out. So if it's a gray line about when the relationship ended, then it might be worth exploring. It's not a question everybody likes, because sometimes, if you're continuing to cohabitate, maybe you're continuing to share bills. And that's something where things have been rather muddled, like, oh, we're still doing all the things a committed couple did, we're just no longer in that relationship. And I've seen cases where if you try to advance that theory of saying everything was still financially entangled, it's not enough, because the whole point is committed intimate relationship. When that commitment and intimate part of the relationship end, it's done. And Melissa,
yeah, the next question is, it's really kind of right in line with that, but the question is, can you speak to the definition of the end of the CIR? What constitutes the end date if you broke up and announced to others that this is the end, or is it only when you physically move apart and stop cohabitating?
No, it's not only when you physically move apart. Just like with a marriage, you can live together and be separated, like that happens. So if you end the relationship and you tell everyone we're done, and you're not still, then you don't. Some people will take a break too. I don't want there to be a misconception about this. You could have a breakup with someone, whether it's in a marriage or a CIR, and it could be for a very short period of time, and fights happen. Johnny went to a hotel for a week because we wanted to kill each other during quarantine, whatever. I mean, that could happen and it doesn't destroy your CIR claim. But if it's like Johnny decided he was going to explore a relationship with someone else and moved to California for 3 months and then we got back together, you might have a problem there. So when the relationship ends is when, yeah, you're telling everyone it's over and you've made the decision, the relationship's done. We're no longer sharing the same room. We're no longer intimate couple. We're now just roommates if we're living together. That when you made that decision and when the relationship as a relationship ended, that is when it's over. It isn't determined by when you move out. If it was, things would be a lot more complicated because there's plenty of times when people move out and maybe one person can't afford to get a new place yet. Somebody moves into another room, somebody moves downstairs. So those things can definitely happen.
Well, it sounds like you have to be able to kind of show something that exhibits.
Emails, very common is like emails or text messages where the parties are like, yeah, we're done. And so saying, no, we weren't. And then on the other hand, somebody might be showing, we kept going to couples counseling after that. Well, hey, then you're still working on the relationship and those were just angry texts. So it's very fact specific. It's really though when the relationship is over and the parties know it's over, even if you're still living together.
Great. Several more questions here. Does length of time living together strengthen your case?
Yes, it does. It's not determinative. Like I will say it's not dispositive where if you didn't live together a long time, you don't have a CIR. That's not true. Like I said, I had a case where it was a little over 2 years and it was a CIR and the court was like all on board with that. However, had another case where it was a 15-year cohabitation, and the longer the case, the longer the cohabitation, the more strong your case is. You can have a case where you didn't live together very long and it's really clear it was a CIR, but if you've been together a longer period of time, yeah, I would say it strengthens your case. Some cases you could live with someone for 20 years. They have a hard time saying it wasn't a CIR.
Great. Okay, can you say more about the definition of pre-relationship assets versus community assets? If both parties had assets coming into the relationship, what would cause those assets to become community assets?
Oh, that's a wonderful question. That's a question people don't know to ask, so good job. Okay, if you have separate assets, and I'm going to put a plug in a minute about how to protect yourself in this situation, but if you have separate assets, like you came into the relationship and you owned a home, and so if you had separate assets and you owned a home, that was your home pre-relationship. That's going to be very difficult for someone to prove it was commingled. Commingling is how separate property assets become community-like. If you had a bank account and you had a bunch of savings in there and then you moved it into a joint account, then you've commingled it. Or if you added the other person to that account, then you start spending out of there together, then you've commingled it. You can have mixed accounts too. Let's say you have a 401k. This is really common. You've got a 401k and you worked at company X for 5 years before you ever started living with this person. Those 5 years, that 401k is separate property portion, and so are the gains and losses from that portion. Then you start living with Johnny for 10 years. Those 10 years that you're living with Johnny and you're putting money from your wages into the 401k, that portion is community. So that's also really important to know. If that was happening during the relationship and then you are breaking up, then again, once you've separated and the community has ended, then that portion of the account post-separation becomes separate property. So pre and post-separation assets are separate property if you can establish that you didn't commingle or transmute them. What is transmutation? This is important too. Transmutation is, let's say I had a house, I totally bought it with all my money, separate property, the down payment was all mine. Inheritance is also separate property. It came from when my grandma died, she gave me money, I bought a house, and then you moved in 3 years later. Well, great. And then I wanted to refinance the house and you were living there and you had great credit and my credit wasn't as good. And I said, I'm going to put you on title and we're going to refinance together. I have then transmuted through a writing and intentionally made this community-like property. So you could take a separate property home and with the stroke of a pen, you could make it community. Or if you never did that and you maintained that, then that person, even if they paid you towards living there, really just paid what the court would consider to be costs of reasonable rent, because they'd have to pay to live somewhere is how the court sees it. So they didn't end up then in a situation where they acquired an ownership interest is what I'm trying to say. So separate property assets have to be traceable. They can't have been commingled, and they can't have been transmuted to become community property.
Okay. One more question here, a couple more questions. You might have said this, but do I have to sign an official document to qualify as a CIR? Does something like that exist?
No, that's what's so scary about it. No, you just have to move in and stay with someone. No, you don't sign anything to say this is a CIR, because most people don't know that that's a thing. There's no like, we're in a CIR document. I don't know anyone that would actually probably want to sign that. There's agreements that you can sign saying, this doesn't establish the CIR. We'll talk about cohabitation agreements because that's a really smart thing to do. But no, there's nothing that you have to sign that says I'm in a CIR. That's not a thing at all. You could do things that are evidence of a CIR, like signing up for like a city domestic partners registry, or putting somebody on your health insurance if you work somewhere that offers, signing up a domestic partner. Those are things that are going to lean heavily towards it being a CIR, but you don't have to sign anything. It's just basically operation of law under these factors in determining whether you're in a CIR.
All right. Do you want to, well, there's a few more questions, but do you want to ask those? Or
do a couple more, and then I'm going to move on to talking about, I talked about how long we have to be together, but I want to talk about a few other like little things to know. And then I want to talk about domestic partnerships briefly. Let's ask a couple more, then I'm going to move on. Okay. Maybe another couple minutes.
What types of actions would constitute the end of the relationship? What if separation was caused by an emotional affair? It's hard to prove the time of separation. You mentioned moving into a separate bedroom. What other kinds of actions would help you have a strong case and establish a timeline?
And establishing a separation, is that what they're asking?
Yeah.
Communications between the parties is the number one thing. Were there messages back and forth? Everybody seems to exchange messages, text, WhatsApp, Facebook Messenger, whatever, email, talking about when the relationship ended or didn't end or what's going on. That if one person says it's over and their actions are consistent with that, then that's when it's over. Even if the other person is like begging for it not to be over. But communications is a really strong thing. Or any changes, like I took you off my bank account, I shut all your access off to all this stuff, whatever it was. When changes happen, when communications happen.
Okay.
Anything else?
Yeah, another participants asking, in terms of looking for proof of the CIR being in existence, she mentions he calls me his wife in conversations. How would we even prove that? That's
a great question. I've actually had that come up in cases. That goes back to the holding yourself out thing. If he calls you his wife in conversations, then you're going to want people who have heard that to show up and testify and say that. That can happen. Or to at least let the other party know, hey, we have all these people as witnesses, and then they kind of know, oh, hey, I know that they always knew I called, Janet, my wife. And so that's probably not going to be great for me if I'm saying this never happened. But yeah, other people can provide personal knowledge of things that they heard the other party say, including, oh, this is my wife. That's a big one, actually. Yeah. The last question that's on here for right now is just if there's an idea of the range of legal costs. And I know that's a real question. This is going to cost you exactly how much the two of you make it cost. That's what I always tell people. This could cost you very little if you both agree that this is a CIR and we're going to divide all the assets and we just work out an agreement. Sometimes that happens. I've had clients where I've been able to help them dissolve a CIR by just doing a property settlement agreement and a final separation agreement that says this is it, the claim is done, this is how we're dividing everything, this is what's happening. And some people will say it doesn't even have to acknowledge it was the CIR. It can just say, this is the settlement we're making. Neither party, acknowledges it was a CIR if there's a discrepancy about that. And, we waive any future claims. That's one way to deal with it. Another way, that's cost effective compared to litigating. If you're going to litigate and one party's going to be like, it wasn't, I'm not giving you anything. And that can happen. It can be very frustrating for the other party when you're like, hey, we lived together for 15 years, is a CIR, and we shared everything. It was a CIR. If you're going to do that, you're going to have to go through like discovery and mediation, and then that doesn't settle and go to trial. It could cost you a lot. So it could cost you, if you put down an advance fee deposit with an attorney, that's typically going to run you, in most family law attorneys in the greater Puget Sound area, around $5,000, sometimes between $5,000 and $8,000, somewhere in there. $5,000 to $8,000 is a pretty typical advance fee deposit. And If you are just going to basically get to settlement, get advice, and be somewhat amicable, you're probably going to get it done for less than that. And that's good. It got you a good resolution, and you were able to not have to litigate. If you have to litigate and file a case, and if you file a case, not every case gets litigated either. Sometimes we still just draft an agreement. But if you're going to go down that road and it's going to become a bitter litigation fight, it could cost you $5,000 or it could cost you $50,000 or more. So it really is going to cost exactly how much the two of you make it cost and how much you fight about it. Okay, that's it right now.
Yeah, that's it for questions right now. Just a reminder to anyone, Michelle still has some content to go through, but if other questions arise, please go ahead and pop those either into the chat or the Q&A, okay?
Good, that was actually a lot of good questions. So you guys have really good questions. Questions that actually come up in real world cases. So that's awesome. Okay, one thing I wanted to talk about, I'm going to kind of get my place now after the questions, is I think I mentioned this earlier, but can we be in a committed intimate relationship if one of us is still married? Generally, the argument is no, there can't be two communities overlapping. And if a marital community hasn't ended, and then how can a new community begin? But there's not actually case law on that. I think it would be a great issue for case law to be established, but the idea is no. But I would question that if one party, I think there's a question about that that's come up in certain cases where maybe one party, they're separated, but they're still married. Can a new community begin? The general answer is no, but it hasn't really been taken up on appeal yet. 3 years is basically the case law that's been established. I mentioned that earlier. People want to know, has there been a case that says a case that was 2 or 3 years? There's been an appellate case where it was barely 3 years. And like I said, I've seen other cases in trial courts where it's been as few as 2. If you've been together 6 months, probably not. That's not really necessarily gonna be long enough. But I think once you get past that 18-month situation, you might be thinking about that this is what's happening. So it's good to plan ahead. And we'll talk about that in a minute. I want to talk about domestic partnerships though, because everybody is there's a lot of confusion about these because they've changed in Washington. And what do they mean? Well, a lot of people will be like, hey, this is my domestic partner. What does that mean? It could mean they're my domestic partner on my health insurance. It could mean I just called them my domestic partner. That's totally fine too. But there's also a legal sense of what a domestic partnership is. Washington used to have, they still have, but it's changed. There's a statewide domestic partnership registry that you can register through the Secretary of State for. And it used to be that you could register for a registered domestic partnership, and that would give you some of the rights. It doesn't give you property rights, but it would give you the right to visit your domestic partnership partner in the hospital, to make medical decisions for them, basically to give them rights of married couples. And that was really a thing before marriage equality. Anybody could sign up for one. If you were any age, as long as you were over the age of 18, you could sign up for a registered domestic partnership on the Secretary of State website. You could get a card to carry in your wallet. You could do all of those things. The law changed, and June 30th, 2014, after marriage equality became a thing, then domestic partnerships, if you had a domestic partnership before then, it was automatically converted to marriage as long as one of the partners was not over the age of 62. So there was this huge domestic partnership registry, and then all of a sudden on June 30th, all these people were married and they didn't know. Well, they should have known because they got things in the mail telling them this was going to happen, and they had to opt out if they wanted to. But a lot of people were converted to marriage. And that's because a lot of people on that registry were same-sex couples. And so now, if you didn't opt out, you were married, because it was basically called the everything but marriage law before. How it also applied to some, opposite sex couples too. However, you can still register on that website. So a true domestic partnership is rare because one of the parties has to be over 16. The other party has to be over 18. That would be a big age difference, but that's the technical parameters. Both parties don't have to be over 62. Why 62? Well, the reason for that is that the state still wanted to give people the right to have, someone making decisions for them, still have that registered domestic partnership, and still be able to make medical decisions and still be recognized as that person's domestic partner. But the state also recognizes that from a public policy standpoint, a lot of people that are older and in maybe a second relationship, they might have a deceased spouse, they might be, divorced or separated, and have long-term benefits that would end if they remarried. So that is why over 62 Social Security benefits start to kick in. And there are a number of reasons why, but 62 is all you have. Somebody has to be 62 now to get a domestic partnership, where you can't get one. And basically it's so you can have some rights, but not terminate the federal rights that you would have if you have a deceased or a former spouse. Other things you have to share a residence, you have to not be married to somebody else, and you have to not be any closer than a second cousin, siblings, parents, those kind of people can't sign up just to get somebody on benefits. Or another kind of domestic partnership, this is actually more common now. It doesn't mean, I don't want to say it doesn't mean anything, but it doesn't give you any rights. Let's put it that way. City of Seattle has a domestic partnership program where if both parties are 18 or older, they're not married, they're not related by blood that would bar their marriage. They have a relationship that I think the words are mutual support, caring, and commitment, and they don't have another domestic partner. You can sign up through City of Seattle for a City of Seattle domestic partnership. Some other cities have them too, but Seattle is really the biggest one. And you don't even have to be a resident of Seattle. You can live anywhere and get a Seattle domestic partnership. They give you a certificate and they say, hey, look, this is a sign of recognition of commitment. Some people do that. They either do it because they know they don't want to get married and they want some kind of a commitment, or they do it because they need to do that to get someone on health insurance if that's required. Is that going to give you any property rights? No, but it could be evidence of a committed intimate relationship. So if you do say, hey, we're going to get a city domestic partnership, okay, but think about the fact that that probably furthers your claim towards a committed intimate relationship. So that's something to know about domestic partnerships. I want to talk really briefly about agreements for unmarried parties. I talked about cohabitation agreements earlier. This is really important. If you're living with someone, or you're going to, you might want to consider a cohabitation agreement. A lot of people don't even know what that is, because why would you? But the whole point is to not end up in a committed intimate relationship fighting about whose property is what. It's to say, hey, we're cohabitating. It's this kind of relationship. Nothing in here establishes a committed intimate relationship, but we recognize we're going to, maybe the relationship will end, just like any relationship can end. And we want to say what our property rights are. A lot of the time I'll draft a cohabitation agreement and it will be very clear that name on title does control. So just like you would think, we kept our accounts separate. What's mine is mine, what's theirs is theirs. And unless it's in both of our names, and we do that intentionally, it's not community-like property. That can happen. That can absolutely happen. And that way you have made a decision for how you want your finances to be handled if the relationship ends. It also will require you giving a disclosure of everything that's separate property coming in for each party. It makes everything very clear and very nice. And that way, if there's ever a question later, it's already been answered. You already know who's going to get what. And that's that. So that's what's really important. The reality is, at the end of the day, you absolutely need to know what your rights are, and know that if you want to put them in an agreement, you can do that to determine what's going to happen when the relationship ends. That's not a problem at all. The next thing to know is that you can't do, this is a thing for unmarried parents. This comes up, I want to talk about unmarried parents briefly, because you could be an unmarried couple and be in a committed intimate relationship. Having a child can be a sign that it's a committed intimate relationship. But again, it's not dispositive. You can also have a child with someone and it's not a committed intimate relationship. But if you're an unmarried, there might be some unmarried parents watching, and it's important for you to know that in an unmarried parent relationship, you cannot decide ahead of time, what's my parenting plan going to be and what's my child support going to be. You can decide what the assets are going to be, like I just talked about in a cohabitation situation, but you cannot say ahead of time, this is what I want to have happen. And the reason why is because at the end of the day, the court is the final say on what the best interest of the children is and child support. So that's not something you can decide ahead of time. You can say this is our intent if we break up, but you can't say this is binding the way that you could in a cohabitation agreement. So it's really important for people to know that. Paternity is also something too. You can't establish in an agreement, I'm giving this person paternity. You have to do a paternity acknowledgement or put that person on the birth certificate. So those are things that you need to do. But typically, if you have children and there's committed intimate relationship, you also will have a companion action dealing with the parenting and the child support, which is really, really important. A couple other things I just want to talk about briefly. If you're involved in a committed intimate relationship litigation, this is something to think about. It can be really stressful. Litigation can be more stressful. Sometimes a committed intimate relationship case is even more stressful because you might have, a lot of the time, you have one party saying, this wasn't a committed intimate relationship. A lot of times because they don't want to give you money, but they're saying it wasn't a stable relationship. And they start saying all the reasons this relationship was different, and they start rewriting history. That can be really stressful and really distressing if you're the person that knows this was a relationship that was long and committed, and now you're stuck with having this other person completely try to rewrite it, usually for financial purposes, but that's what's going on. And that is a bad thing. So yeah, get help if you're in that situation. It can be really stressful to deal with. And I have to tell you, it will help keep your legal costs down if you have the right support, because a lot of times attorneys are even more expensive than they need to be, because you might be really upset and really stressed out. And I would love to talk to you about it and offer my advice. And I do, but I'm not a mental health practitioner, and I can't give you the tools that you need to cope. And talking to me about how to cope is going to be way more expensive for you and make your case way more expensive than it needs to be. Talking to someone like Melissa, or, talking to friends is great too, but talking to someone that can give you tools to help you get through this is going to be much better. It's going to keep your case costs down. It's going to make things more palatable for you while you go through what's a really stressful situation, especially if someone's denying the relationship. That can be horrible. I know that from having clients, that it can be really, really distressing. You don't want that to happen. So Melissa, what are some tips that you can give to talk about how to reach out in a separation situation, even if it's not marriage?
Yeah, no, definitely. I mean, rallying your support network is absolutely key. When you're going through a situation like this and having to get involved in this legal battle about what the relationship was even about, and now it's going to be ending. There's just so much, gosh, complicated emotion that's coming up as you're going through all of this. So yeah, rallying your support network, making sure that you're around people in your life who are positive and not judgmental and who care for you unconditionally. That's really, really important. Finding an outside support person, to finding a therapist or a counselor who you can talk to, just to sort of have a little bit of a objective perspective on what's going on, and how to help support you through the emotional upheaval that you're involved in, I think is absolutely key. We find a therapy provider often through your insurance, potentially. You can also search private provider networks or look on Psychology Today to find a therapist. I'm a therapist who specializes in relationship transitions. I think it's really, really an important resource for folks, and I just couldn't recommend it enough. It really doesn't matter if it's a divorce or a separation from a committed intimate relationship. It's hard and it's complicated, and you're trying to untwine your life with this person, and from a relationship that was potentially meant to be forever. It's really, really hard, and you shouldn't have to go through it alone, and you should have adequate support to get you through it.
Definitely. Especially if someone's making accusations that can be really, just really hurtful. I want to get to any last questions we have before we run out of time. Melissa, do we have any others?
Let's see here. Yes. One more question about the statute of limitations, please. If the CIR ended 5 years ago with no written agreement or settlement, can one party still file a claim?
Anyone can file a claim, but no. If you file a claim, I would file a motion to dismiss based on you're going to be in a tough situation after 5 years trying to prove that you should be able to file a claim. By operational law, you have 3 years. That's all you got. So even though there might not be a settlement or a claim, you've missed your window. So no, nobody can file a claim. Here's the thing I should say. You could file a claim. Anybody can file a claim, but I wouldn't advise you to do that. Or if you're defending on a claim, I would advise you to try to deal with it swiftly to extinguish the costs. Anybody can file a case. It only costs however much it costs to file. $360.49 is a typical amount, but it doesn't mean that it's going to be successful. If someone filed a case when it was a 5-year statute of limitations, I'd bring 12B6 motion to dismiss because there's no question. If there's a question about when the relationship ended and you really want to, say, hey, we might have gotten back together or whatever, that's different. But 5 years is too late.
Right. And then another person just says, just to confirm, when I move out, I have up to 3 years to file a CIR case. It sounds like
yes,
that's
exactly. And it's not even just when you move out. If the relationship ends and you're still living in the home and you're living together. Some people will live together for a long time just because, they don't have another plan, or maybe you need to sell a house or whatever you need to do. keep in mind that when the relationship ends, that clock starts ticking and you could be in that situation. So I think that's it, right? Or do you
Yeah,
have
I think that's it. Well, actually, sorry. Let's see here. We have one more. We had somebody who is a current client who made a nice comment about you, Michelle. But there's another question here. Okay, when I was in the process of selling the house. What if I was in the process of selling the house that she has submitted for a CIR? She's not paying for the mortgage and I need to sell it. Will the CIR
stop you?
title
Yeah.
stop me from being able to sell it?
Yes.
Could I just put half of the equity in trust if it's not allowed? Could I get a renter instead? If I stop making payments on the mortgage, will it affect her credit as well if she's on the CIR?
Great questions. Let me answer this question.
If I can't sell, how can she file a claim and force me to continue to make mortgage payments and not contribute?
If somebody files a CIR case and there's a house that's in question, you can't sell it. I mean, typically one party will either move for temporary financial restraints if they're not automatic in your county, saying that no one can buy, sell, or do anything that's not in the course of ordinary living. Selling a house that could potentially be community character would not be a good idea. And if there's a case open, it's probably not going to close because it's going to come up that there's a claim against the property when the title company sees that you're in litigation. And if you don't do that and you manage to get it by and it manages to close, you're in a bad spot because then you're going to look really bad and it's not going to be good for you. So is it going to affect someone's credit if it's not in their name and you stop making payments? No, it's not. But if like the house got foreclosed on or something, you could be in a bad situation then because it was potentially community and you could have created losses for the community. So you don't want that. I would say the best thing to do is get a renter if you don't want to live there until the case is resolved. That's what I would do. I would definitely not recommend selling something once a CIR case has been filed. If no case has been filed, you can sell or do whatever you want to do. You might not want to, if that person's going to come back and file a claim later, you might want to work out a property settlement agreement. But definitely, if litigation is filed, talk to an attorney before you make any decisions like listing a property. Yeah.
All right. I think that covers our questions.
Oh, I think there's one more. Do you give advice on how to shore yourself up before filing? Yeah.
Sorry about that.
Yeah, that's all right. I just saw that one just pop up. That's the easy one. Yes. You know, how to get yourself in a good position, everything you're going to need to know, everything that you're going to need to have with you. Yeah, definitely. We can talk about that. We're running out of time today and it's really pretty much fact specific, but this is a good point. Melissa put our contact information up. You could always schedule a consultation. We could talk about what you might want to do before you file, the things you're going to need, the documents you're going to need, what's going to happen, kind of the expectations for the case. That would be something that I think everybody needs to know. So anyway, I wish you the best and I hope you have a great day. Thanks for joining us today. We enjoyed spending this hour with you. If you have other questions, you want to reach out to me or Melissa, you've got the contact information on the screen. Another thing just to note too is if you're not sure if you have a CIR and you're thinking about filing a case, it's a really good idea to get an opinion. That would be great. Okay.
I also want to mention that Michelle and myself both participate in a meetup group called the Do's and Don'ts of Separation and Divorce. There's actually a meetup group this evening and monthly. It's another resource to go to find lots more information about, the do's and don'ts of separation and divorce. We team up with a financial advisor and a real estate professional as well to answer your questions. And that's on the Meetup app or meetupgroup.com.
Yeah, a meetup is tonight. So did you say that?
Yeah.
Yeah. You said tonight. Yeah, I didn't say
tonight, and also monthly. It's not just.
Yeah, it's monthly. So our meetup group is in the evening, and like Melissa said, there's a great panel there. It's not just me talking the whole hour, which is nice. But there's a great panel there. We answer questions. We used to do this in person, which was lovely before COVID. We would meet and just get to talk with you in person and buy you a meal. We can't do that anymore. Maybe someday, we really hope. But right now, you can join us online, meetup.com. You can also go to our Facebook page and find information there. But it's the do's and don'ts of separation and divorce. So if you want to get more information, it's not just, it's separation and divorce. So it's not just case specific to divorce. Please join us And we'd love to chat with you further then. You can get direct interaction with me, Melissa, a real estate professional, financial planner. It's just really great. So that's another thing that we offer. Our next webinar will be next month. We'll touch on another topic. And if you are signed up for this one, you'll probably get information on that too. So thanks so much. Have a great day. Take care. Bye-bye.
Everybody, thank you.